No, not in 5 minutes.
You will also argue.
Yes. So
Each of the principal responding.
One minute. We told you, sir, everyone this side will have your turn. So whichever, whoso. you-
kindly allow me.
Will have your say, sir.
I won't take more than half an hour.
You may take as much time, there is no rush, we told you already.
It's so great.
But don't repeat us.
No repetition, my lord.
Yeah, Mr. Pradhan.
Since your lordship is interpreting the concept of dearness allowance and dearness pay, just 2 paras from one judgment, and then I come straight to the point, on which your lordships were debating just when my friend Mr. Subramaniam concluded. The compilation which they had given, please, the second judgment of the compilation, Bengal Chemical and Pharmaceutical Works, page 49. Please see that. Para 17 onwards. 4 paras I want to read, because that will indicate and perhaps may show some light on the way your lordship will interpret Rule 3.
Yes.
Page 55, para 17. 4 paras only I will read. Before we deal with the contentions of the learned counsel, it will be desirable to refer to a few decisions of this court, laying down the principles that have to be borne in mind when a claim for dearness allowance or revision of dearness allowance is considered. So these are the principles which have been laid down. In so-and-so versus Calcutta Tramways, it was observed, we can now take it as settled that in matters of grant of dearness allowance, except to the very lowest class of manual laborers, whose income is just sufficient to keep body and soul together, it is impolitic and unwise to neutralize the entire raise by cost of living, in the cost of living by dearness allowance, more so in the case of middle class. So the concept of dearness allowance, because pays are fixed, this dearness allowance in its very basis is something which keeps on increasing, because the purpose of giving this to an employee is to neutralize the rise in the cost of living. Please see the next judgment, how your lordships have further explained. As pointed out in the Workmen of Hindustan Motors versus Hindustan Motors, the whole purpose of dearness allowance being to neutralize a portion of the increase in the cost of living, it should ordinarily be on a sliding scale and provide for an increase on raise in cost of living and decrease on a fall in cost of living. I pause here. It can happen, my lord, if inflation ceases and we go in fact we go in the reverse direction. When the formula is worked, it may even reduce. It is hypothetically possible, though practically never so as in the world we live in today. But the issue I'm wanting to flag is, one, it is to neutralize a portion of the increase in cost of living and should ordinarily be on a sliding scale to provide for an increase in the rise of cost of living. Your lordship can leave para 19, come to para 20. In Ahmedabad Mill Owners Association, it has been emphasized that in trying to recognize and give effect to the demand of a fair wage, including payment of dearness allowance to provide for adequate neutralization, industrial adjudication must always take into account the problem of additional burden which the wage structure would impose upon the employer, and ask itself whether employer can reasonably be called upon to bear the burden. In Kamini Metals, it has been noted that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is always a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Now your lordships is crystallizing what your lordships full neutralization is not normally given except to the very lowest class of employee. The purpose of dearness allowance being to neutralize a portion of the increase in cost of living, it should ordinarily be on a sliding scale and provide for an increase on the rise in the cost of living and decrease on fall in the cost of living. This is what I wanted to point out. So when your lordship will interpret this rule, this is the principle which your lordship would keep in mind, that the whole concept of dearness allowance abhors the notion of fixed allowance, because the whole concept and purpose being to offset the increase in cost of living and therefore sliding scale is the normal notion as your lordships have understood, not today, but from the very time when this concept was brought in. Now, with this background, my lord, now kindly see Rule 3. I have 4 points on Rule 3 to make to your lordships. I can start immediately after lunch because then it will be one.
How much time you have?
Half an hour, my lord, because I'm not going to repeat what my learned friend said.
Just want to know.
Half an hour, I just want to read some parts of the original CAT and the first High Court judgment. And yes,
I'll be half an hour after that.
Okay.
So whatever time left for me,
No, you have all the time. We'll carry it out.
I will not take that after this argument, not more than 20 minutes.
Okay. So, anyone else who's to argue this side? So we move from the premise that today this side would conclude.
Yes.
We move, and then tomorrow.
After Mr. Patwalia, will that I shall take up and.
My
No,
lord,
no difficulty. Even if you are not concluding today, we continue tomorrow. But we are just letting them know that tomorrow the hearing would begin. It would continue. That's all. Thank you.
good.
Kindly allow me to deposit the directed amount in registry. I'm late by 1 day. I have to deposit on 5th and today is 6th month. Kindly allow me to deposit today.
Which matter, ma'am?
The matter number is 3179 of 2025. My Lord's order is of 21st July. This time will be tendered yesterday, my Lord. Much obliged. Much obliged.
So, my lord,
My lords, before Mr. Patwalia starts, it had fallen for my lords that.
Mr. Patwalia, are you frowning?
no, I'm not.
You are frowning?
No. I'm only concentrating.
Okay. But with a smile.
Yes.
So, my lords, it had fallen from my lords that something from the central government that connects the AICPI to the dearness allowance. And we have the annual report of the Labour Bureau that creates the AICPI that does so in detail. So, when my turn begins, I will place that.
No problem, I told you already.
Yes.
That's it. Rest of the board to be discharged. Rest of the board to be discharged.
Yes, our apologies, we had made it yesterday, clear yesterday though, but not today. I don't think so, the council may wait in the other matters. We'll continue.
Rest of the board will discharge.
That's it.
So, my lord, so far as the central government rules are concerned, we have got them, my lord. I can pass on the copy. Identical provision. Absolutely identical. Just pass on 2 copies. On the second page is Rule 3, which gives the definitions, and Rule 3, Sub-Rule 3.
Just 1 minute. Yes.
Rule 3, Sub-Rule 3. Existing emoluments means the sum of 1I is existing basic pay, dearness pay appropriate to the basic pay, and this is a fixed amount. Your lordship knows when the pay commission revise, it is basic pay and then dearness pay. Sometimes now it is called grade pay, whatever. And then dearness allowance, which is a newer concept, which is dearness allowance appropriate to the basic pay plus dearness pay at average index 536, base year 82 is 100.
Parameter.
Exactly this. So, now your lordship may just come to the rule.
Yes.
So, because it is exactly the same, I may just add one more sentence here. Yearly calculation on quantum, therefore, necessarily has to be the same. If our argument is accepted, then yearly calculation of quantum has to be made by the state government, and yearly quantum is made by the central government. So, because the formula of computing the quantum is the same, the percentage will always remain the same. Therefore, this saying that through the back door we are asking parity, that's not a correct way of putting it. There is no back door here. When the rule is implemented in the way we are propagating, it should be implemented as against their static argument, which actually is a very bright one, which has arisen right here before your lordships today for the first time after so many rounds earlier. But anyway, so if it is to be calculated as they have been doing it, they did it up to 2009, as we said it is correctly to be done, as the High Court says in the first round, which I will very briefly show a few paragraphs, and therefore the percentage will have to remain the same. It is not our saying, please give us parity. When the formula of calculation is identical, the parity has to follow with the central government on percentage. Then what is our problem? Really, our problem is the frequency. Apart from overcoming this new argument, which is now of static, the problem throughout actually in this litigation has been of frequency. The central government religiously revises it twice a year. Actually, really speaking, if somebody has to have a literal operation of the rule, it must happen every month. But that's not feasible because index is revised every month. That's not feasible. So central government is doing it twice a year. The state government initially for some time did it, then started doing it once, then used to have gap years, not even once, and then ultimately a full stop. So therefore, this parity that through the back door you are claiming parity is actually an argument which is a red herring. The equation, the equivalence on quantum is on the operation of the rule. And our problem only really was on frequency. The government was not giving it because they said we have money, finance. That's what they said, which has been rejected throughout. And I'll cite one or two judgments. Now the question is on interpretation of the rule or on addressing the argument of this static argument. Now please have the rule. I have 3 points on that, my lord. Very quickly I will make them and then show those earlier orders. The rule your lordship can have from the typed version of the rule, my lord, which is at page 127.
Yes.
It's read many times, my lord. One more time, I will just read it quickly.
As many times as you want.
Because ultimately, my lord, this will what is going to decide the fate of all of us and also the state government in that way. So, dearness allowance, your lordship is got it, appropriate to basic pay plus pay at index average. Now, what is index average? I will not say. I am going to read 3 paragraphs of the note Mr. Diwan gave on behalf of the state government. Please have that note. Because that answers the static argument completely. That note, clause 3, 4, and 5.
Yes.
Now, please have clause 1 and 2 also I'll read all. AICPI is an abbreviation of All India Consumer Price Index. Sometimes it is also called CPI. Somewhere your lordship will see it as CPI only. So AICPI is an abbreviation for All India Consumer Price Index. This index is published by the Labour Bureau Shimla, which is under the Ministry of Labour and Employment. Now, next 2 are very crucial for my argument. The Labour Bureau revises the index average twice a year on 1st January and 1st June. So therefore, index average is well known to everybody when the expression is used in a pay revision rule. And when that expression is used to calculate a dearness pay, which is a concept to offset inflation and compensate to some extent for inflationary trend, then it is the Labour Bureau revises index twice a year on 1st January. The broad purpose of this index is to enable adjustment with respect to inflation. So therefore, I say, my lord, this index average with 82 as the base year in itself is obvious to the person framing the rule and obvious to the person who is to be the beneficiary of this rule that this index average is an average which is revised from period to period, and 536 with 82 as base year, as my learned senior friend, my lord, Mr. Subramaniam showed your lordship, that is the denominator. Because when it increases, for example, if 536 becomes, say 750, then what is to be the increase in my pay? So then because 536 is the constant, we divide 750 by 536 and multiply by 100. That's how we take out a percentage. I mean, I had forgotten from my 10 plus 10th days, but now I have relearned it. That's how we work out the percent. What do we say? 5%, 2%, 8%. What is that figure? That figure is this index average divided by 536 multiplied by 100. So my lord, therefore they never raised this argument. It is so obvious that we are actually trying to meet a situation which on one side is so obvious and clear, and the proof of the pudding is in the eating. How have you been implementing it? You have been implementing it the way we have been saying it. What is then our problem? Our problem is the frequency of the implementation. Our problem is not that you wrongly understood it, but today, when you want to implement and you are faced with a huge amount, according to you, then you want to wriggle out of it. And therefore, this kind of an argument is now brought up by saying it is static. The submission is why I started with that judgment. Static is just opposed to the concept of dearness pay. A dearness pay can never be static. Otherwise, it is not dearness pay at all. Then it becomes a DA or a grade pay or a pay scale. Dearness pay, and it's not, I am not saying it, therefore, it is that judgment of your lordships where your lordships have explained the concept. And in the first round judgment, this is the way it has been put to grant it to us. The tribunal in the first round declined it to us, saying no right. This is the way it has been put to grant it to us. They filed a review which got rejected and the judgment became final. There was no further challenge. So, my lord, at least between them and us, they are bound by that interpretation, if nothing else. That is, according to me, my weakest submission against them, that they are bound by it. It is a submission. I am raising it that they are bound by it. But according to me, it is my weakest submission. Because the very concept of dearness pay, the very concept of index average, the very purpose of mentioning 536 with 82 base year, and the way you have worked on it, are clear pointers that you were never in doubt that it was not a constant. So, my lord, this is one which I am saying. Then, so the index average I have explained, mention of 82 by 100 is my second point. My third point is that this argument of static is abhorrent to the very concept. That's my third point. And my fourth point on this issue is that your conduct, that's my last point on this interpretation of the rule. Now, my lord, just see with me the first round judgment, because was there ever in doubt that it is not static? It is constant. That goes with the first round, my lord. Just very few paragraphs I want to read from that first round judgment. That is P25. It starts at page 368. At 369, please have page 369, para 3.1.
Yes.
Para 2, the original application was filed by the applicants before the learned tribunal seeking following reliefs. A direction upon the respondent to forthwith release 50% dearness allowance, which is due in January 2006, immediately within 1 month. Direction to immediately comply with the report and recommendations of the 5th Pay Commission. I can leave the rest. Now, please have para 3, the first part of it. The learned tribunal arrived at the following finding at the time of dismissing the application. Payment of dearness allowance to the employees of West Bengal was absolute prerogative falling within the discretionary domain of the employer, and infraction and refusal on the part cannot result in denial of accrued right of an employee for getting dearness allowance. Though part of the recommendation of the 5th Pay Commission might have been acted upon, it did not entail that as a necessary corollary, the same had to be carried to its logical conclusion. And the third was the issue of discrimination. So the tribunal had no vested right, their discretion to grant or not to grant. Then, my lord, your lordship may have page 375. These are, your lordship may only note these paras 24 to and 25. The argument of the state that it is the above submission para 24 made on behalf of the petitioners and are vividly opposed by Mr. Kishore Datta, learned Advocate General. According to him, the finding of the tribunal was that claim of DNS allowance was not based on any legally enforceable right. According to him, pre-revised scale of pay employee has been transformed from band scale so and so. According to learned Advocate General, after an initial fixation, no formula exists for fixation of DA to the employees for subsequent period, etc. Then how the court considers it? Your lordship may come to page 377, para 31.
Yes.
Before entering into the issues involved in this petition, it will be profitable to recollect settled principles of law relating to relationship between government and its employees, public servants, right of government to get remuneration, introduction of the concept of DNS allowance to government employees, and mode of performance of function. Then, my lord, relationship between employees is discussed. I need not take your lordship's time on that. Page 379, right of government employees to get remuneration is discussed. Then, my lord, introduction of DNS allowance to the government employees starts from para 38. Kindly see the opening line of para 42. 43 is what I will rely on. 42. DNS allowance was introduced to meet increase in cost of living, which was initially known as food allowance. It is a peculiar concept to India, Ceylon, Pakistan, Bangladesh, while dealing with the concept of DNS allowance. Then Hindustan Lever is already cited on the next page, that underlined portion. Basically, the concept of DNS allowance was designed to combat inflation, to protect real wages, and therefore it should appear there should be 10% neutralization. This is a concept peculiar to India, Ceylon, Pakistan. Now, para 43 is the finding of the court that after introduction of variable DNS allowance, the allowance comes at a revisional rate at periodic intervals for the central government employees and state government employees. The change rate is calculated after taking into consideration the increase or decrease in consumer price index. This is a finding recorded after hearing both of us in a judgment which is final inter partes. Beyond this is exactly what they are now trying to resile out of. So if I can just read this para again, Lord. After introduction of variable DNS allowance, the allowance comes at a revisional rate at periodic interval for central government employee and state government employee. How can he argue today static? The change rate is calculated taking into consideration increase or decrease in consumer price index. This is exactly what we are saying. And this is the finding in a judgment inter parties and a detailed judgment. You went in review, you failed. Now, my lord, moving forward, my lord. Your lordship may come to page 383. They have dealt with, my lord, para 47 regarding recommendations of the pay commission, etc. I need not read it now, my lord. Your lordship would see. Then 383, whether the claim of employees legally